Those who I haven't yet met, my name is David Samuels, and I am GAR's publisher, and what that really means is I've been with GAR since the very beginning. And GAR and events in Delhi have actually gone all the way back almost to the very beginning. One of the first and most memorable things I did when GAR started was to come to the opening of then the LCIA India in Delhi, which was in an auditorium, but not this one. And I have to say how much things have improved in the time since then. And also in those days, I was in the back row, scribbling away on a notepad, and nobody knew who I was. And a man called Jan Paulsen was at the front of the stage, and everyone knew who he was. And today, this sounds weird, I feel a bit like Jan Paulsen. So, arbitration joke for you. A few housekeeping details, and then I'm going to hand over to the chairs to get us properly underway. Your great spiritual need is Wi-Fi, and that is very easy to find. It is completely free and obvious on your device, so nothing more to be said there. I would like to say a huge thank you to the sponsors that you can see on stage. We are truly in your debt. We always used to take sponsorship slightly for granted, I'm ashamed to say, but then COVID came along, and without the support of sponsors, we wouldn't have kept our events program running at all or been able to come out of that period as well as we have done. So we are in your debt. It really does mean a lot, and we thank you. And then last but not least, GAR Lives like to think we have a motto, and the motto is less talk, more conversation. That conversation should be between the members of the panels, but also between the stage and the audience. And we very much hope that you, the audience, will join in. That's generally not a problem in our Indian events, we find. When you do join in from the floor, can you also say who you are nice and clearly before you make your contribution so that we can keep track of things, because we are GAR and it's very possible that at some point we may wish to quote you. If we were to do that, we would be in touch with you and everything would be sort of checked out beforehand. So you are very much in a safe space, but if you could say your name nice and clearly, it's very useful. And with that out of the way, I think I will pass it over to Gautam, and I look forward to seeing you all. Oh yes, complaints department. Any issues? Come find me or one of the GAR staff, and we will make it right. Oh, Srikrishna.
A very good morning to you. It's wonderful to see all of you bright and shining, and early on a Saturday morning. We have a great program devised for you, and we hope that you enjoy every moment of that. I would request Gautam to give you the details of what you have in store for you for the day. Gautam, where are you?
Thank you, Justice Srikrishna, and good morning, everyone. Thank you, David, and I just want to say a few words. A very warm welcome to GAR Live Delhi. It's wonderful to be in Delhi. It's been an absolutely energizing and uplifting last few days. Very enjoyable. This is the second time that GAR has been in Delhi. It's been 4 years since the last time, which was on the 29th of February 2020, just before the world changed. So it's wonderful to be back here in Delhi. Justice Srikrishna, the GAR team, and I hope you will enjoy the day and find the discussions on our panels engaging and stimulating, and that you will participate by asking as many questions as you can possibly ask. There will be, as part of our program today, and I'll come to this, an arbitrator's question time, and there will be opportunity for you to pop questions that you wish in advance so that we have some level of spontaneity to add to the proceedings. We hope you make many new friends in the course of today and meet existing friends that you've not seen for a while. GAR events are all about the interaction between the audience and the panels and networking. So please indulge and make the most of it. The morning panels, which will begin very shortly, will cover arbitration reforms and the aim of making arbitration better. And then we'll then have a session on the current state of play in the area of investor-state arbitration. We will then have a keynote address from Justice Rohinton Nariman, who, as you will know, was one of the most prominent and influential Indian Supreme Court judges of recent times. After lunch, we will have the DAW Arbitrator's question time that I made reference to, and we really want as many questions as possible from the audience. We'd like to have some fun in that session, so let's make it as fun as we can. Following that, we'll have a panel exploring the resolution of climate disputes through arbitration, very topical in these days of heightened interest in the environment and ESG. The finale will be the DAW live debate, this year on the role and impact of artificial intelligence in international arbitration, and whether it will, for example, mean less arbitration hearings and the less need for arbitrators. So nothing controversial there then. Following today's conference, there will be a drinks reception kindly hosted by Saraf and Partners, held at the Taj Mansingh Lawns, a short distance from here. So we hope that everyone can attend those drinks. Before we get going, though, I wanted to just take a few moments to cover off a couple more things that I believe are very important. First of all, yesterday was International Women's Day, the 8th of March, and indeed, given time zones, it's still International Women's Day in some parts of the world, like Hawaii, the west coast of the US and Canada, so we can still celebrate International Women's Day. We need to continue to celebrate women. And I would ask every woman here today, and those who will be joining us later, to take a bow. Please continue to be fearless, be passionate, lift up your voices, fulfill all of your potential, continue to thrive and flourish, and lead. You're all winners, you all belong, and I'm proud to be one of your champions and allies. Men should love it when women succeed. There are many amazing women in the course of my career and in the course of my personal life that I'm in awe of, who inspire me. And we must all continue to fight for true gender parity and equality. Nothing less is acceptable. Secondly, I would like to remember and pay tribute to someone very, very special to many of us, and that was Fali Nariman, who very sadly passed away on the 21st of February at the age of 95. Mr. Nariman was, and always will be, a legend, a true icon, and one of the greatest lawyers and arbitrators, not just in India, but globally. He was a wonderful human being, mentor, teacher, inspiration, and friend to so many of us. I personally was blessed to have been able to call him Uncle Fali. I wanted to be like him. I still want to be like him. He made me want to be better, and he still makes me want to be better. I admired his character, his genius, his artistry, his integrity, and his principles. He was a true one-off. There will never be another Mr. Nariman. Everyone who knew him was infinitely better for it. We will all miss him immensely. But to adapt one of the titles of one of his many amazing books, our memory of him will never fade. This DAW held in Delhi, a city he graced for many, many years, is dedicated to Mr. Nariman. I will now hand over to my co-chair, Justice Srikrishna, who I'm also blessed to count as one of my dear mentors and teachers, and who, like Mr. Nariman, is one of the very few globally to have been given the DAW Lifetime Achievement Award. Thank you, and I'll hand over to Justice Srikrishna.
Thank you, Gautam. My dear friend Gautam, is it on?
It's green.
Oh, okay, you have to do it. Okay. Green means go. That's it. I got it. My dear friend Gautam just told you that the International Women's Day is on in some part of the world somewhere because of the time differential. That's the same logic he uses to get a sundowner, because he'll say the sun is down somewhere else in some other country. Jokes apart, I too miss Mr. Nariman. Fali, as he called him Uncle Fali, I used to call him Fali because I knew him from my bar days, though I was all of 21 and callow when he was already in his 30s and a rising star in the Bombay High Court. The great thing about him was, despite the age difference, despite the difference in wisdom, learning, and standing at the bar, he was always a friend. So many times I have appeared with him in the Supreme Court, and I have been the recipient of the invitations to his house and had the good fortune of the hospitality of his lovable wife, Babsi. Never did I feel that here was a legal colossus and I am a nobody in the legal world. I also had the good fortune of having him argue in my court, both in Bombay as well as in the Supreme Court, and it was an undeniable pleasure. That he was a legal giant is known to everybody, but that he was a great humanist with a very kind heart, amiable, and always ready to smile at a joke at himself or anybody else in the world at large. His affectionate and kind-heartedness came through from every word that he spoke. I shall, of course, miss him as a dear friend, and we shall all miss him as a colossus of the legal world who is no more with us, though we hope that we have learned enough lessons from his model life as a very ethical, very straightforward, and down to earth lawyer to whom law was as much his spirit, law was as much his life as correct behavior was. Ladies and gentlemen, may I propose that in honor of Mr. Nariman, we observe a minute of silence before we continue with the proceedings. Thank you. And to continue with the proceedings, Gautam will give you the highlights of the stellar life of each of the speakers here and give you a brief introduction of what they are and what they are about to talk about today. Gautam, to you.
Thank you, Justice Srikrishna. I'll keep my introduction very brief because we've got a brilliant panel and we've got two absolutely amazing co-moderators. So what I'm going to do is I'm going to just tell you we've got Sneha Jaising of Barucha & Partners and Sai Subramaniam of Saraf & Partners, who will be co-moderating a panel on arbitration reforms, how we make arbitration better. So on that note, I'll make it better by handing over to you. Thank you.
Gautam, sorry. Can you? Yeah. Good morning, everyone. Thank you, as Justice Srikrishna said, for gathering so early on a Saturday morning. Our panel today is on the proposed Arbitration Act reforms. Is it time for a change? As we were reading material for the panel today, I couldn't help but think back on last year's GAR Live at Bombay when the keynote speaker, the eminent Justice Patel, called on us to burn down the house while calling out fundamental flaws in the arbitration system. Today, we have an opportunity to test the arbitral systems. The proposed reforms in India and the UK have caused intense debate and scrutiny. And I think we will discuss whether it's time now to come for a shift in our approach to arbitration. While our panel needs no introduction, fulfilling our duties as moderators, we will introduce them anyway. We have Mumtaz Bhalla. Mumtaz is a partner in the arbitration and dispute resolution practice of ELP. She is also an advocate on record at the Supreme Court of India and has been recognized by several legal directories for her exemplary work. We then have Rajesh Pillai KC. He acts in high-value, complex commercial disputes and has significant international arbitration experience. In addition to his UK practice at 3VB, he is also called to the New York and the BVI bars and appears in multiple jurisdictions. We then have Hasit Seth, who is an experienced arbitrator, counsel, and mediator based in Bombay. He is a licensed attorney in New York, and he regularly serves as an arbitrator in both institutional and ad hoc arbitrations and has 25 years of experience and actively promotes institutional arbitration. And last, but certainly not the least, we have Atul Sharma. Atul is the executive chairman of Denton's Legal. He has over 4 decades of experience in both domestic and international commercial arbitration, is also well recognized by several global legal directories. Right. Now, a quick question to the panelists before we sort of delve into detail. And please be brief, because I just want to know each of your first thoughts and takeaways on the proposed changes to the Indian Arbitration Act. So I'll start with you, Mumtaz.
Thank you, Sneha and Sairam. Thank you, Gautam and Justice Srikrishna and Gar for putting this together. So the very fact that India is open to accepting that we need reforms in the last 8-9 years has been a welcome step. The 1996 Act came in, and the first massive attempt that was made to reform the law was in 2001, which led to the 2000 bill, which never formed into an act. But the very fact that between 2015 and today, we are talking about reforms again and again shows that we understand that there are challenges. And no matter what we talk about making India into a hub of international arbitration, till we reform the law and make it more Indianized in its approach, nothing is going to happen about making India into a big hub. I read the 2017 report by the high-level committee chaired by Justice Srikrishna, and it had some beautiful recommendations about institutionalizing high-value arbitrations, but that's not seen the light of the day. There are implementation challenges. So every time I'm asked to comment on something about reforms and reports and amendment to the laws, reforms will come in, reports will come in. If the implementation is not made in the right way, we are still at a position where we have a foot in the door, but we are not really reformed. So those are my opening remarks, where I would say that it's a welcome step. We are more conscientious about the whole thing, but still a long way to go. Thank you.
Thank you, Gar, organizers, Gautam, Justice Srikrishna, and the audience who has come on a Saturday morning. So there is a new report out by former law secretary, and also he was an official in the Lok Sabha, called Dr. Vishwanathan. So that's the Vishwanathan report, which came out in the first week of February. So there are many aspects to it, but there are 3 key aspects I want to point out which have potential to wreck domestic arbitration. No less. So the first one is Section 34. So it has been a big effort for the legislature to convey to judiciary that your intervention has to be minimal. Yet intervention has been there, and modification of the award happens quite often. And that's the reason that the business community finds that even if you get an award, there's always a chance that there will be interference in it. So what the Vishwanathan Committee recommends is that you can partially or wholly set aside the award And if it is set aside, then in the interest of justice, you can pass, an order which would meet the ends of justice. I don't know if this is even worse than an appeal. This is appellate powers plus Article 142 powers given to the court which will set aside or review the awards. The second aspect is the small claims. This has to be, some genius kind of recommendation, because it proposes a tribunal, an adjudicating authority, because of the IBC's success. The adjudicating authority composed of High Court and Supreme Court judges for small and medium value claims. I mean, and this is to be appointed by an arbitral institution. And the order would be executed as an order of a civil court. I mean, I just don't know how it will play out. I mean, maybe I haven't understood the whole thing as such. The third thing is that they want to introduce a civil procedure, for arbitration. The whole flexibility of the arbitration, which is its main USP, they want to introduce model rules of procedure, because the argumentation is that everybody follows different rules of procedure because we said that CPC and evidence will not apply. And yet they have a caveat that, strict rules of evidence will not apply. So these are the proposals which are there in the report. They will be much debated, discussed, dissected. So, but I am just putting out before you the three main aspects of it. There are many other tweaks. Some of them are definitely required. Those are the positive steps about it. Certain judgments have commented that some reforms are needed. So those are very positive steps about it. But otherwise, it's a dangerous report.
Thanks, Hasit. Atul, coming to you. Are the reforms actually reforms?
Yeah. I would start with a slightly lighter note. I was asking Shreyas as to whether the report is now official, not official. But one thing which troubled me was it has 111 pages. And that reminded me of Nelson. You have the test going on right now. And I would tend to believe that the bails are still on the stumps and we don't have a Nelson here. And you don't need David Shepard to jump and, ward away the evil. But on a serious note, I think all our reforms after the 2015 have been retrofitting. And we have been retrofitting it in the context of what the courts have decided on different aspects of the Act. So far as the current reforms are concerned, obviously they are arising out of the lessons that we have learned out of all the judicial pronouncements. But surely you have made progress. And the progress at different life stages of the life cycle of arbitration, its enforcement, challenge, etc., has been steady. If you come out with a kind of a balanced scorecard on a scale of 10, so far as the appointment process is concerned, it is kind of somewhere around 6 on 10. So far as Section 8, 11 challenges concerned, I think again we are quite near 6 or 7. So far as the timelines for arbitration, there's been a huge improvement in terms of how much time the tribunals are taking to decide. 34, 36 are still gray areas, but I think it is not the creation of the statute, it's a problem with the whole system. So that, of course, when I come to the second part of the ecosystem as to what is the true reform, I believe that you need a whole amount of coordinate reforms. And those coordinate reforms are not merely confined to the amendments. But that does not mean that we stay away from these reforms. These reforms will deliver in some form or the other. It is always a process because today we don't even have things like asset tracing as a recognized tool of enforcing an award. You don't have a very developed regime, virtually have a non-existent regime of the experts coming in for the purposes of deposing. And half the tribunals don't even realize that the value of experts, And so that these are the things which are developing. And unless we have these reforms coming in at different intervals, you will not be able to self-correct the whole system. It's a self-correcting system. Slow, it's like trudging along. But one or two aspects which are very good is the whole concept of, this debate which has been going on for a decade about the seat, and that has been sorted out. There have been some issues with regard to, and the whole, this, I would call it a kind of an unending saga of the stamping. That has been sorted out, but then when you're coming out with a non-obstantive provision and it is going to override all laws, I don't know how it will play out in real life, because if you have an award which is not stamped, the tribunal might have the power to ignore that, and I think there is a vague expression there with regard to the appropriate stage. How does it play out in real life vis-a-vis the authorities under the Stamp Act, and how the penalty provisions will come in? Because you can't take away, if you're having a non-obstantive provision, I think we should have closed it here itself as to what should be the penalty. Because if you go for an adjudication before a stamp authority under 33, then they have the power to impose penalties of 10 times, up to 10 times. So these are certain gray areas. But all in all, the devil will lie in the detail. These are only recommendations. We don't know what the language of the proposed amendment statute is going to be.
Thanks, Atul. I just want to remind everybody that Chatham House rules apply. And also for the benefit of our audience, so the Vishwanathan Committee report that has been referred to has not been formally made public, though it is widely circulated, and the committee does recommend that it be made public. Coming now to Raj.
Just to add to that, with a sense of responsibility, that whatever is being discussed over here is purely from public domain and not otherwise. So none of us are held responsible or accountable on any of what is being discussed here.
Raj, why don't you tell us a little bit about the UK reforms?
Thanks, Sneha. Hi, everyone. Look, I'm going to be relatively brief because the English position, and it's been set out through the Law Commission, is that there's nothing much to see here. We're fine. And that smugness, I think, stems from the 1996 Act, which was a very good reforming statute. And so we'll pick up on about 6 points. But in truth, where we are with the English support of arbitration is that it's viewed as a strong centre which upholds the primacy of arbitral independence and awards and light touch judicial interference. Structurally, we had our Law Commission report. I don't know if it's quite the equivalent of the Vishwanathan report we've talked about, and there is now a bill going through Parliament, by which I mean the proof of the pudding is already there in the sense that we have the drafting that we will be looking at. And the first thing that I wanted to talk about is the arbitrator's disclosure obligation. And now that exists already as a matter of common law. We'll all be familiar with it. You have to disclose conflicts if you've been put up as an arbitrator, so as to avoid potential bias and challenges. So what we have here is just a statutory codification of a test. And the language of the law is going to be that the arbitrator must disclose what they're aware of and what they ought reasonably to be aware of. Now, how that plays out will be a matter of case law, but it isn't just subjective, because the importing of the language of they ought reasonably to be aware of imports that objective analysis of what they should know given their position. So there is going to be some duty of inquiry, but it'll be fact-dependent. So I think if you are a sole practitioner, then you can check who you worked for and so on and do that relatively easily. But if you're a partner in a law firm, it's going to be a little harder. And you would, I think, be expected to carry out a conflicts check. as you would if you onboard a new client. So I think structurally, hopefully, nothing would change. What may happen is arbitrators might try to shift responsibility onto the parties, because the IBA guidelines on conflicts from 2014 require parties to tell the arbitrator if there's any link, because you may not know. So you may, if you're an arbitrator, say, look, can you comply with that? And that would be a way through. The second thing I'll talk about is summary disposal. But now, in England, we have in the court system what we call summary judgment. And what's happening here is there will be a statutory power. But again, that's a power that any tribunal already has. Okay, you can entertain an application to say, their case is rubbish, knock it out. Why do we have to spend 2 years and millions of pounds going to the end of a hearing? The test will be, under the statute, that whether the party has no real prospect of succeeding on a claim or defense or a specific issue. Now, that reflects a well-known English procedural test, but that will be superseded if the institutional rules have their own provision for summary disposal. Now, for example, another test that is known is if there's a claim that is manifestly without merit. You have that in LCIA, ICSID, SEAC. And SEAC obviously has the immediate judgment. So this, again, is nothing new, but the thought behind it is that it may encourage tribunals to be a little bit stronger and a little bit firmer. I think the phrase used by the Law Commission is that tribunals can otherwise have due process paranoia, right? That we're too scared to do it, when actually everyone can see that this is nonsense. So hopefully, if you have robust tribunals, and this isn't something that's going to happen without argument, each party has to have a reasonable opportunity to put their case and respond. The third is about the law governing an arbitration agreement. Now that has shifted, because really the thread in the common law in England has been that unless parties had expressly agreed the law governing the arbitration agreement would be the law of the matrix contract, so the contract in which the arbitration agreement was found. That would be effectively by an analysis based on implied choice. Relevance of what the law of the arbitration agreement is, of course, you could need it to determine the scope of the arbitration agreement, arbitrability of the issues, jurisdiction. So it is important. And now the default position is that the law governing an arbitration agreement will be the law of the seat, so English law. And that is partly protective because they are worried that maybe the law of the contract might not be as supportive of arbitration as the policy is in England. So they're saying, well, if you haven't done it, it's going to be English law. And English law, for example, on questions of scope, is notoriously broad. You have what the then House of Lords had the Fiona Trust principle, one-stop shop presumption of what falls within it. The next thing is about emergency arbitration. Again, that's now well established, so the Act is being brought up to date. Fifth, there's a narrowing of jurisdictional challenges, because in England, often what you do is if you're challenging jurisdiction, you do it in the arbitration, and if you lose, you could have another go in court. But now what's happened is that the procedural basis on which you would challenge in court is narrowed, and you can't run an argument that wasn't run in the arbitral challenge unless it couldn't reasonably have been discovered. So, I mean, the point is to narrow the scope of that. And then there are two things that didn't go in. There was an attempt to have a confidentiality obligation, but it's thought that that's in the too difficult category because there's so many different exceptions and under different jurisdictions. And there was also an attempt to have an anti-discrimination provision about, can you say that an insistence that an arbitrator be of a particular identity or a particular qualification, etc., can't be done. And where they've got to, again, I think, is it's in the too difficult category. I mean, it's a hot button topic anyway, broader than the scope for today. But bluntly, I think there's not that much has changed. I think what I've just run through is all stuff that's familiar to the people in this room. Query, did we need it? I think Angeline Welsh described this as jurisdictional marketing through legislative reform, in which case I'm an unwitting instrument of this marketing sitting here. But we're at a different stage there, and I'm glad that we are. And I was very interested to hear the differing views already on the Indian reforms.
Thanks, Raj. Hasit, we're going to pick more from where you left off. You've given your preliminary thoughts on where the proposed reforms are leading with your views on Section 34 and 37 and the powers of court to modify. Could you walk us through a little more on what, from your perspective, do you consider to be the most significant changes in the report? And is there anything that you believe has the potential to sort of enhance the efficiency of Indian arbitration, domestic arbitration?
Yeah, sure. One of the interesting aspects is emergency arbitration is supposed to be now a legitimate aspect of the Indian arbitral regime. So although MCI rules included, some other rules also included institutional, but it's been given statutory support. So that is a very welcome development, because without that, it's an experimental kind of project for anybody who is an arbitrator or institution, proposing that in the rules, because how the courts would rule on it would be unknown. So that has been very positive aspects. There are lots of small tweaks about timelines, where certain things were left to, ultimately the default of Limitation Act. So those have been improved. So those were much needed. But I think putting emergency arbitration right upfront and giving it full legitimacy, including how the orders would then be dealt with the main form tribunal and its execution, I think that's a very positive reform.
Timelines. Are these timelines progressive? We see a lot of the provisions have nearly curtailed the timelines, but these are not definitive or strict timelines to be complied with from our experience as to how courts have dealt with. Where do you think these reforms are going to lead?
Yes, for example, to refer a Section 8 matter, it's like if you have filed a suit instead of an arbitration where the agreement includes an arbitration clause, and you have a procedure to take it back to the arbitration or take it to arbitration. There's a timeline now for it. But how much time the courts take, we have seen in the appointment process under Section 11, that it's just left to them. How would you decide a fixed timeline for them? So, and some things they've tweaked, for example, the time to file pleadings. It was 6 months. Now they said that's the maximum. It could be lesser. And then, your timeline, for further timelines actually work from that point onwards. But there's no sanction if you don't do it. That's neither now, neither after the court. So that's something.
Mumtaz, the Vishwanathan Committee, a lot of it seems to be, well, I wouldn't say borrowed, but sort of legislating what our courts have said on the Arbitration Act and how the law has evolved thanks to our courts. Now, the focus was, of course, to make India arbitration friendly and ensure that ease of doing business in India is promoted, and therefore it's important that the courts support the arbitral process and that it's not an interventionist approach. Do you think the reforms have actually, attempted to make our courts a supportive factor in arbitration, or do you think it's still interventionist?
So I feel there are some welcome steps in the report. The first being the clarity on the issue entertained in 9.3, because almost in all the disputes that I've handled, 9.3 has played a very important role, because the earlier 9.3, the current 9.3 says, once the arbitral tribunal has been constituted, the court shall not entertain an application under subsection 1. Now, there has been a Supreme Court judgment in ArcelorMittal's case where it says, entertain means application of mind. And does it really minimize court intervention? The answer is no. So I feel the reforms suggested seek to address this problem by saying entertain should be replaced with shall not proceed. So there's more clarity. So steps like these, because a lot of times there could be a situation where if you file an application under Section 9, because an application under Section 9 can be made before, during, or after the proceedings. But a lot of times, the second part of 9.3, which says, unless it renders relegating the issue to the arbitral tribunal efficacious, the courts are going to retain the power. So when you use the word entertain, there are a lot of disputes going on around that. And with Supreme Court saying that entertain means application of mind, almost all the disputes were finally decided by courts, although a tribunal was in place. So I feel that reforms such as these, where words shall not proceed are there, unless the remedy is efficacious, are a welcome step. Putting timelines in Section 9. Current situation says that if you have an order under Section 9, within 90 days, an arbitration needs to be initiated. Now, it's suggested that within 30 days of a first order that you get, which is an interim order, you should constitute a tribunal. I think it's also a welcome step, because if the idea is to have minimal court intervention and have party autonomy in resorting to an arbitral mechanism, courts should just be there to fill in the gap and handhold you where there's nothing else to do. So if there is a tribunal in place, and despite making a request to the tribunal, it's a 3-member tribunal, you're not getting a hearing, and there is a subject matter in the arbitration which can face damages or anything of that sort which is urgent in nature, yes, courts should be there to handhold you. But where there are routine issues and the tribunal is there, it should be left to the tribunal. The second major thing that I feel is, again, like Hasit had pointed out, institutionalization. A lot of challenges in the Indian market are regarding appointment of arbitrator. It begins from the first step. A party will send issue a notice for invocation of arbitration. It's a 3-member tribunal. The other side does not respond. You wait for 30 days. Then you move to court under Section 11. Then instead, despite Bhattacharyya saying very clearly that you need to see if there's an arbitration agreement and if there's an arbitrable dispute, it's at least a 3 to 4 months procedure, even in an original jurisdiction court as a high court, where you get to see an arbitrator being appointed. So if you institutionalize arbitrations, at least the high value ones, because I'm not very sure how effective this could be in a small arbitration, but if you institutionalize high value arbitrations, the procedure becomes more effective and you narrow down the disputes regarding challenge to an arbitrator. So I do feel there are some welcome steps. And how I've been seeing, like I started by saying that between 96 and 2015, there was nothing consequential happening, and it was just courts that were coming in and telling us, this is what is to be done, this is what is not to be done. And like Atul said, that we are seeing what the courts suggest us, but we are ultimately implementing them somehow. So once there is an implementation, you narrow down disputes, because if there's no statute which says something, it's always left to interpretation of the courts, and we'll find judgments either way. For example, in 29A, there are varied decisions across courts in India. Some say that you need to make an application while the mandate is existing, while the others say that, upon termination of a mandate, they become functus officio. So will you really come and make an application after this? But the committee report seeks to address it by saying that that application can come in even later, because a lot of times, as we've seen in a case of Delhi High Court, there was an application made 1 year after termination of mandate. And the court said the award is ready to be rendered. What is the purpose which will be solved if we get into the technicalities of the wordings used in 29A? So I do feel there are welcome steps, but I don't see that there is something concrete which addresses the issue between the interplay of Section 12 and 14 of the Act. You have the 5th schedule, you have the 7th schedule. I feel except a few additions here and there, they're almost similar in their essence. Now, courts have said if there's de jure ineligibility, you can straight away come to courts. But if there is a doubt, then the tribunal can decide it. So the grounds in 5th and 7th schedule are almost the same, except a few additional grounds here and there. So there are parallel issues. And there's no clarity on what actually forms a de jure dispute, and we're still going to go by court judgments where they go on aspects to clarify that if it actually is a direct ineligibility on conflict and bias, you come to court. But the good thing that the committee has tried to do is address a challenge to an arbitrator, which is made before the arbitrator by providing an appeal mechanism. Now, when clients come to us and they say that, we feel there's a doubt on the independence of the arbitrator, a lot of times we have to tell them to be conscious of the fact that the dispute is going to be decided by the same arbitrator. And the only remedy they will have if he decides to go ahead with the arbitration is to take it up at the stage of 34. So we are looking at a 1.5 year timeline, an arbitrator coming in and saying, yes, I have jurisdiction. How much do you irk him by that action? And then you wait for an entire process of a 1.5 year or 1 year, depending on how much extension has been granted. You are reigniting the whole issue by way of a 34. Why don't you bring in a mechanism, because principles of natural justice says you can't be a judge in your own cause. So when you allow an arbitrator to decide something like this, you're letting him decide if he's fair and impartial or not. And if that issue comes up before him and you have to go through an entire arbitration for a year or 2 years before him and take it up in the 34, it just defeats the purpose of giving a finality to the award rendered, under the Arbitration Act. And it also defeats the entire purpose of getting an expeditious disposal of the disputes. So there are some really welcome steps. And like I said, we have a foot in the door. Rather than getting new laws which don't take us anywhere, we should just try and reform the existing laws to suit our situation more. And I feel that these are some welcome steps.
So you mentioned 29A. Just a thought, I was just wondering, did we need 29A at all if parties consent to extend timelines? I mean, just a thought.
So what the committee has also tried to do is bring in a single party request to court as well, that even if the parties by consent don't want to do it. And I feel a 29A is required because when the act was brought in new, when the amendment was brought in, initially the courts were very, very open to giving extensions. And it's only when the Supreme Court came down heavily that you need to justify reasons. So if that level of scrutiny is not there and it's done in a very mechanical manner, we are again going to come back to a situation where we are getting these six-month extensions as a routine. So I do feel that court intervention at this stage for something like this is required, because if the court is asking you that there are genuine and plausible reasons, and a lot of times the courts have actually held that if it's because of the arbitrator, we'll see that if there can be a reduction in the fees of the arbitrator. So I feel that while there is a inherent right within the parties to do it for a given period of time, but if you want to give conclusivity to arbitration and not let people get an impression that arbitrations will go on forever in a country like India, you need to have a provision like this where courts tell you that, okay, is there a reason that you have, or is it a very mechanical application?
Thanks, Mumtaz. One of the key agendas that we were going to discuss today was whether we believe the reforms go far enough to improve arbitrations in India. Atul, with this, I'm going to come to you to ask whether, in your view, the suggested reforms are purely procedural, potentially limiting party autonomy, which, as we all know, is the key to arbitration, and whether these suggested reforms, does it lean towards more judicial intervention, or does it lean towards reducing judicial intervention and giving more party autonomy?
See, in my view, the whole system is not matured enough, right? The whole ecosystem of arbitration, when you're talking of interference by courts, it's in the background of the maturity of the system. For example, we have been talking of institutional arbitration for, as Mumtaz said, that we have done nothing about it. We brought the amendment. We never notified the provisions relating to the new arbitration center. The kind of infrastructure that center has. So all in all, we needed an element of discipline in the whole system. And that discipline could either come through institutional arbitration, or it could be brought in through judicial intervention to the extent that minimal, but it was required. For example, 29 Mumtaz said that you needed some supervisory authority in terms of to justify that why you are doing it. But all in all, this is okay. This is all, as I said, retrofitting, amending the statute is fine. But there's a huge amount of coordinate reforms which are necessary to really make the regime meaningful for the litigant or for the party who wants the dispute to be resolved. If you look at the whole gamut of arbitration disputes, 70 to 80% will be arising out of public procurement processes. Now, we have done nothing about the regime. I think that when does an arbitration start? Do you think that it starts when you give the notice of invoking arbitration? The arbitration, in fact, starts when you write the arbitration clause. Now, what is the regime of your contracts? You look at public procurement contracts. You talk of EPC or concessions. You bring in FIDIC, Silver Book, which is a standard thing for these kinds of contracts. Then you start doing violence to FIDIC. Just because you wanted to de-risk the government or the procuring authority from the fundamental risks underlying the project. We actually need a standardized regime of risk sharing and arbitration clauses in public procurement. That will solve a good amount of the problem, and don't need to, because as I said, this is all troubleshooting. Why do you create trouble in the first place? The second aspect is that when we are talking of complex disputes, we have not created sufficient capacity within the system. Capacity, whether in arbitration disputes, let's put our hand on our heart and let's understand how many qualified technical people are there to do construction arbitrations as arbitrators. Of course, in the last few years, all kinds of experts have, all these outfits have come up. But how many people are really equipped to handle a technical issue on a construction arbitration? How many people do you really have to handle technical arbitrations arising out of IT contracts, service contracts in the IT space, ITES? We have not created any capacity there. On the one hand, we're not creating any capacity, and then we create this phobia about retired judges. And frankly, today, in today's system, you remove these retired judges from this arena, there's absolutely nothing there. So what is it that we have created in terms of bench strength of arbitrators? We talk about the law, but we don't talk about the training. We don't talk about training arbitrators in the space where they are domain specialists. So we don't have contracts managers who are acting as arbitrators, which is a universal practice. We don't have, I remember when the first committee was constituted for the revival of this center, which has now been notified, I think it was Mr. Nariman and 2 Supreme Court judges, I think Mr. Venugopal, and 2 more judges of the Supreme Court. Actually, you need to create within this arbitration center 3 divisions: commercial, construction, and ITES. You have bodies available here who can create that capacity. For example, about 6 months, or maybe, 5 years ago, I had this discussion with the Royal Institute of Chartered Surveyors. And we started training arbitrators in the domain expert area as well as judges. So today, there are about 7 judges who have undergone training, retired judges who have undergone training for acting as arbitrators in that space. That service is going to be launched. Now there is an MOU which has been entered into between Royal Institute of Chartered Surveyors, which has an India presence, and the new center. to create a panel of those arbitrators. Similarly, you have FICCI, you have CII, you have all these commercial bodies who can create that capacity for you. But we have really not done anything substantial on those kinds of reforms. This will continue because the judges will continue to give decisions. We will continue to retrofit the whole system to fit into those lacunas. But real ecosystem is the actual arbitration process, starting from the drafting of the clause, right up to the conduct, and then creating that capability which instills that confidence so that the judiciary doesn't have to come in. That, I think, is the fundamental requirement. This will continue to happen, and this will yield results. Then you'll again have another set. Probably you then again realize where the lacunas are.
Rajesh, coming to you. Anything that you think that the UK recommendation should have adopted from the Indian regime or vice versa?
That's very unfair of you to ask me. Look, the serious point is that without seeing the drafting, it's difficult to say. Atul opened with saying the proof is in the pudding and these are recommendations. I don't think there is anything to actually check against. But one question that I think I have, particularly arising from what Atul says, more generally for this room and the panel, is should there be a trend of more specialism within council, which is something that we do have more. We have a construction bar, we have a technology and construction court, for example, to pick up on what you were talking about. I've had disputes where I'll issue it in the commercial court about aerospace manufacturing. And the commercial court says, well, that's going to go to the TCC. And we have that, and, IP and so on. And I think my experience is much more generalist commercial disputes counsel here. But the people who become judges presumably practice first, and they have that hyper-specialization. Is that something that would be useful? And is it a realistic career choice for a young lawyer to make?
Thanks, Rajesh. We don't have too much time left, but just very quickly, closing remarks from each of you. And just one particular point I'd like all of you to address. And it's just picking up from the theme that each of you have spoken of, which is that we do have arbitral reforms and they come a couple of years, when reports are published, the statute is amended. But do you think that it's a question of implementation, and particularly specifically relating to enforcement? Because very often I think we are able to cross the hurdles at the stage of the arbitral proceedings, but then you end up having a paper decree, and enforcement is an entirely different process. Even though we've had the Supreme Court say that you can execute and enforce at the same time, especially in relation to foreign award, you still have cases where it's gone up to the Supreme Court, it's been held to be enforceable, and you're still back before the executing court. And ultimately, the company that is being fought over, or the asset that has been fought over, is frittered away. So just a couple of thoughts, starting with Atul. And then
sorry,
we'll go
just
down.
to add to that, to Hasit as well, from a domestic point of view, with your views on the power of the court to modify an award. If the 34 and an enforcement under 36 or execution run in parallel, where do you see the problem if the court has modified an award and the executing court is considering the award as a whole? There is going to be a roadblock. So do you have your views on that? If you could touch upon that when you give your closing remarks after Atul.
As I said, there are few recommendations, obviously, in the context of the Chatham House rules. I hope that I'm not being quoted somewhere. But the proposals are, in some ways, quite proactive. So far as the enforcement is concerned, I think the biggest reform which can really act as a deterrent is the cost regime. So the cost regime is something which has been virtually non-existent in this country. And in fact, cost regime could even go to the extent of a penal provision in terms of it. So penal cost is something which could be a very good, and the fact that now you're proposing to have a deposit, I don't think that the fact that it is going to be modified is going to be a problem, because you will have a mechanism built. I think what is recommended, there is a mechanism built in, and it can be undone through the mechanism of securing that amount which has been to be secured and deposited and paid. And then the withdrawal today, in any case. In fact, Bombay High Court used to have a rule, original side rule for all these years, even in suits, where you could be called upon to deposit the money, and that mechanism the courts have been regularly following in terms of how to secure the reversal in the event of a modification.
Regarding enforcement, I mean, that falls into the domain of your civil procedure code. I think the whole system, since it was built in 1908, is based on a single asset class of land, land being the most valuable asset class. And that's why we have a large set of rules for that class. Now, today, with financialization of the whole economy, where asset classes are more liquid, more financial products, I think you can have a much more faster mechanism for those kind of assets. For example, I can tell you there's an award against the government of Maharashtra, and execution proceedings were launched, and an attachment order was issued on the government's account with the Reserve Bank of India, where stamp duty amount is kept. And they found out that there isn't enough money in it at the end of the day when the attachment was laid. So, I mean, it would be very easy to build a set of rules for financial assets as compared to this thing. I mean, land and all that, anyway, it's a huge, beehive of interest. I mean, securing awards through like auction of lands, that seems to be very far-fetched in this day and age.
UK courts tackle these problems?
Sorry.
I said, how does the UK regime tackle such problems?
In terms of costs, or I mean, more generally, I think in terms of efficiencies and what you touched on with execution, is that the judges have a touchstone of being pro-arbitration, right? And again, they have specialist arbitration bars, and that's their instinct. And I think that, I mean, as Atul has said, reform is to be welcomed. And even if it is tinkering around the edges or retrofitting, it's better than not. But if the touchstone for those assessing these reforms and those implementing them at a judicial level particularly is this an arbitration-friendly outcome? At every level, not just at the Supreme Court, but at every level, that would be the way to make it efficient and to make parties and their lawyers think, listen, this is worth it, we're going to carry on, we can do it efficiently.
Mumtaz, your views?
So in concluding what I wanted to say, I wanted to touch upon Atul's remark on technical arbitrators and as opposed to retired judges. I do agree that there is a trend in India, but I think that trend is not due to any lack of reform in law. It is more due to mentality of people here to get a perfectly written award. Nobody really wants their award to be susceptible to challenges, although we know that challenge to an award under 34 is very restrictive, but we all are practicing counsels and every award will get challenged under public policy on some ground or the other. So I feel the resistance is not in terms of law, it's in terms of the mindset of the parties as well as the councils. And nobody is really ready to take that risk of putting in a technical expert as an arbitrator who would be well equipped to answer issues on technicalities in a construction contract, as opposed to a retired Supreme Court or a High Court judge who will be able to balance those facts with equity and law at the same time. So rather than getting any kind of a reform on that aspect, I think it's the mentality, it's a collective effort of the stakeholders. And that is where you narrow down issues regarding enforceability as well, because prior to the amendments, getting a stay to an award was a joke. And now the stay to an award is, just like you get a stay to a money decree. There have been deposits called for by courts. Prior to this committee also suggests that there should be minimum deposits, 50% in form of a deposit and 50% in form of securities. Now, if somebody who's a judgment debtor, if you tell that person come and make a deposit of 100%, it actually leads to a settlement in most of the cases. And I've seen an increasing trend where courts have also ordered 100% deposit and permitted parties to withdraw that deposit. Now, steps like these are welcome for enforcement, because when you are asking someone to deposit 100% in court and the other party is actually encashing that money, the issue of execution becomes an empty formality, and they also understand that 5 years down the line, if the money has gone from my pocket today, 5 years down the line, the outcome may be something. So except a few cases where the government decides to go ahead and challenge and make the deposit, I've seen that it increasingly leads to settlement of disputes even after the award. So there are welcome steps, and I feel that collectively, as once all the stakeholders get together and they decide, because like Rajesh said, there is a paranoia that you need to have a perfect award. The more sound your award is, the more finality it will bring in. That is what leads to somebody more responsible and somebody who's more capable of writing a reasoned award being the choice of the parties and the counsels for the parties. The law doesn't come and tell you to get an arbitrator who's a retired judge. It's us who eventually get into that. So I feel that, that is one thing that I wanted to point out.
Thanks.
I think we can all agree that while reforms are good, it's really the implementation and it's a mindset change that is required. I think we have time for questions there.
I think we have time for one or two questions, considering we're almost at the end of our allotted time. Maybe one or two questions from the panel, to the panel rather. I think there's someone at the back.
Yeah. Sushil Shankar here. Mr. Atul Sharma said something about there not being enough arbitrators, and if you remove the retired judges, there would be no one left. With all due respect, Mr. Sharma, I'm not too sure where you are getting this information from, because there are literally hundreds of young, smart, capable, trained people waiting in the wings to take over as arbitrators. Actually, if you look around in this hall itself, you'll find quite a few of them. I'm not too sure if you're referring specifically to construction arbitration. It might be the case there. But even there, it's not as though the retired judges are trained in construction arbitration. And there's always the solution that you can get technical experts to assist the tribunal. I'd agree with the observation of Ms. Mumtaz Bala that it's more of a mindset than a real problem. And in any case, it's going to be a chicken and egg problem. At some stage, some stage people will have to take over. And if you say that they're incapable, then the situation will continue forever. And one last observation. Even if you say that you want a perfectly written award, trained people who go through arbitration training are also trained in writing awards, and pretty good ones at that. Thank you.
I don't think that we don't have that capability. But where is the bank? Who has created that bank? Today, as any practitioner, if somebody asks me, can you suggest the best person to act as an arbitrator in a take or pay contract in oil industry or gas industry? Where is that bank? We have absolutely no structured system of creating that bank. In fact, on the contrary, I believe that we have a huge pool of capability. We've completely ignored. We've done nothing about it. But the fact remains that those people also need to be trained to be an arbitrator. It is not simply being an expert in oil industry to be good enough for being an arbitrator. You need to have some sense on how the arbitration works, what are the stages, how this whole gamut of amendments has come about, what is the background of this, how you're supposed to behave, how you're supposed to conduct yourself. Judges have spent their life doing this. They know precisely what is to be done at what stage. There's nothing happening in this country. So that's the capacity we need to create. And I'm not for a moment saying we don't have the people. We have the capability, but they're not available. There is no pool, there is no training, and we lack. That's why I said, in fact, there are bodies who can do it for you. Let's join hands with them and create that pool and have access to that kind of talent to act as arbitrators.
Sorry, I'd just like to come in here. I think it's also important that the onus lies on each one of us to ensure that we encourage these appointments and train people and make sure that we change the mindset.
No, but let's be honest. Can you suggest something to your client that, look, this is the pool. These are the people. Can you recommend? Put your hand on your heart and say, you can't. Today, I can't. In this country, there is nothing available in public domain. There is no utility which is housing that data.
Yes,
I just have a quick question for the panel, especially those Hasit and others who chose to excoriate pro bono work for several months of the year. But my point on a more serious note is that we perhaps, and I invite your comment on this, which is there a need for us to institutionalize the process of reform? And that is, I think, a point that both Atul and Mumtaz made, which is that we will periodically need it. But that has to be data-driven, and that must be not episodic or ad hoc, but it must be done periodically. So I feel that this extreme commentary without a reason is unhelpful.
Yes. Shreyas is one of the members of the committee which wrote a part of the T.K. Vishwanathan committee report. So, but the institutional mechanism to do law reforms is the Law Commission. It's an executive body. I mean, that's its difficulty. I mean, lots of times it has a head, it does not have a head. And one of the things which Shreyas mentioned is correct, that our law reform is not data-driven. It's opinion-based. It's my opinion versus somebody else's opinion. That has to go. I mean, we need, while you can't have completely data-driven stuff that, we have a report where, 1,500 people out of, 2,500 say we need this reform, hence it should be made. Because surveys are surveys, ultimately. I mean, so, but, some kind of objective data analysis as to how things have functioned. Because we can, as Atul sir had mentioned, that this is retrofitting, and tweaking of laws which will keep happening. But at least can we have a review mechanism that the last round of changes, how have they functioned? I mean, and what has been our experience, and documentation to go with it, so that in the next round, we don't repeat the same mistakes. For example, I'll tell you, the law as the legislature has made is essentially in the appointment of arbitrators that you just need to look if there is an existence of the arbitration clause. And then through judgments after judgments, we have added more and more filters, and judiciary has firmly implanted itself as gatekeepers to arbitration. Now, they can do it, I mean, that's fine, I mean, through interpretation, but the difficulty is that, then the time it takes. I mean, if you don't want it to be a simple administrative appointment, then do it very fast. I mean, like whatever it may be. But you want to challenge arbitrability, you want to see limitation, you want to see, subject matter issues, all kinds of things, then it's bound to take a year and more. So, I mean, there needs to be some analysis, I mean. So, pardon my extreme commentary, as Shreyas said, I mean, but I'm worried about the three things that I have mentioned. An adjudicatory body of retired High Court, Supreme Court judges for small and medium value claims, that is, I mean, way beyond my imagination. Thank you.
Thank you, Hasit. I think we are...
Sir,
sorry.
I'm Rajiv Shankar Dwivedi. What Mumtaz said that about section 12 and 14 and how they are dealt at the end of the award, there is another extreme to this. So every time an award is passed, the party who is challenging it, the first attack they make is on the arbitrator. They say that he was not competent, he did not do this disclosure, that disclosure. Now, these are some information which ideally can be given only by the arbitrator in the court. So is the arbitrator supposed to engage a lawyer to defend his award? Because if he does not do, then other parties, they cannot speak on his behalf. So what would be the remedy of that?
Which is why I felt that the best remedy is to bring in an appellate thing suggested by the committee is a good step. Because if you try and if you tell an arbitrator that you will come to the court to defend your award, it's going to minimize them from accepting your mandate most of the times. This is an arbitration I've seen where we take legal opinions and they're not ready to come to court, and it's fair on their part. Expecting an arbitrator to come to the court will be far-fetched. So probably the only way that I see is one of the suggestions that is brought in by the committee, which is bring in a challenge measure and appellate measure at the initial stage, because ultimately, why to put someone through the perils of trial of 1.5 years and then say, oh, this person was not competent to hear my dispute. And if this is narrowed down in the initial stage, and it can be made time-bound, if there are suggestions to make appointment of an arbitrator time-bound in 30 days under the new suggestions of the Vishwanathan Committee, we could make an appeal decision also time-bound, because then everybody knows where they're starting from. And the object of Section 34, which is the award is final until it is against the, the grounds put in, which is, like I said, the most challenged round is public policy. You know that these things will not come in the way of it. When the statute allows you to do it at the stage of 34, it is a hurdle that you are creating. And one of the panelists had actually said, why create problems in the first place that you eventually want to address? We also need to understand the minds of people who are litigating. You, after 1.5 years, you tell them, okay, you have an award against you, and we want to bring in this challenge. They will say anything to save my position. But is it fair on them to bring in something like this when this could have been decided 1.5 years earlier? So I do agree with the suggestion made by the committee that there should be an appellate mechanism, because it just puts the controversy to rest at the right stage.
Sorry, I think we've been reminded by the organizers that we're completely out of time. So we'll close here. I believe there's a short coffee break before. Oh, there's no coffee break now. Sorry.
From there. Thank you, everyone. And I thank all the panelists for their views. And I hope we've set the motion for the rest of the session and rest of the day today with the first session. Thank you, everyone.
Sorry, slight correction. We do have a coffee break now. My apologies to Sneha. We do have a short coffee break. We'll resume in 15 minutes, please. Thank you.